Hello everyone, welcome back to SEBI Grade A legal classes. I'm Rajni Yadav. I'm your tutor for today's class and I'll be teaching today administrative law. And we'll be covering this subject also from this exam's point of view, and we'll be covering the main and important aspects which might be asked in the question. So we'll be covering the relevant provisions and aspects of this subject. So let's get started without wasting any time. And okay, so first of all, let me introduce the subject and what exactly it is. Administrative law is a law which deals with the administration. Right? Administrative law is not based on statute. That is to say, you will not find any legislation or any statute which is exclusively talking about it, because it's a part of Constitution, and rather it is also called as a judge-made law, because this administrative law is also considered to be a manifest of the judge's decision. That is, it is also has come through the judge's decision that they give. Right. So, yeah, both the constitutional law and the administrative law are concerned with the government functions and are a part of public law. Constitutional law is concerned with organization and functions of the government, and administrative law is concerned with organization and functions in motions, something that we do in day-to-day basis. So yeah, this is basic an introduction about the subject. Now let's go ahead. Okay. So basically, this administrative law is based on an English concept, which is rule of law. This term rule of law was originated by Sir Edward Coke, and it was developed by Dicey. He was an English scholar. So you must remember this name, Dicey. This name here is important, Dicey. They might ask this question, and because this has also been previously asked many times in various exams, so you must know. Dicey was the person who developed the concept of rule of law. This English concept, rule of law, is based on 3 principles. And these principles, when you read, that is supremacy of law, second principle is equality before law, and 3, dominance of legal spirit. You'll see that these principles, they are also in a way, or they're also enshrined in our Indian Constitution. So, right, you can say that rule of law is also based, or it is also one of the manifestation of our Constitution. Because these principles are somehow, when you read the Indian Constitution, you'll find these things mentioned there. Right. So now let's read these principles one by one. First one is supremacy of law. That is to say, no one is above law. Right. So let me explain you this first principle by one example. Suppose tomorrow it happens that the government says that from now onwards, the elections will happen in every 20 years and not in every 5 years. So can the government do that? No, it cannot do that, because it is the job, it is the duty, it is the work of it is something which is given to us by our Constitution. This is not in the hands of government to, they can't do this. They can't get up one day and decide that now elections will happen in 20 years. Because we all are governed by the Constitution. Everyone has to follow and abide what is written in the Constitution. You cannot overrule what is written in the Constitution, right? So no one is above the law. So no one is above. And the law of our countries are Indian Constitution. So you cannot go above and beyond what is written and mentioned in our Constitution. Second principle, equality before law. That is to say, every person is to be treated equally. You can't just differentiate between 2 people, right? You have to treat everyone equal. You have to give each and everyone equal weightage, importance, right? It cannot happen that if there is a common person, if they're a president or minister or something of that good or high position, you can't differentiate. The law is equal for everyone. If some punishment is prescribed for a common man, that will also be for the person who's holding a good position in our country. So every person is to be treated equally. Third principle is predominance of legal spirit. That is to say, legal spirit has to be respected and valued. So I'll explain this one also by an example. Suppose it happens that there's a judicial magistrate who is in Agra and issues an arrest warrant against a person who lives in Delhi. So can he do that? Of course, he can do that. Why? Because this power has been given to him by our CRPC. He has been given this power. He's empowered to do it. This is not something that he is doing it in his individual capacity. He's doing it because he's empowered to do it. He is doing it in his legal spirit, right? So these are the three principles, that is supremacy of law, equality before law, and predominance of legal spirit. You must remember these principles. They might ask in the MCQ question, they might ask which one, they might write these three principles and add one more, and they can ask which of the three or how many of them are the principles of rule of law. Okay, yeah. Now, there was a saying earlier, the king can do no wrong. You think, is it applicable nowadays also? No. Nowadays, this saying is not anymore applicable because now we all follow the rule of law. That is to say, even the king, that is, earlier we used to have the concept of king and all, but now we have ministers and president, judges, bureaucrats. They all will be held liable if they will disobey the law of the land. Because now law is equal for everyone. Nobody will be given preference or any importance before the law. Now let's come to the other aspect, other concept which is there in our administrative law is separation of power, right? Whenever we talk about the term separation of power, first of all, you should know that this term was given by, first time this term was given by a French scholar, that is Montesquieu. He coined this term, right? So actually, basically what happens in our government, there are three organs, right? One is legislative, other one is judiciary, and the third one is executive. So let's know what all these three do. Legislative is that organ of our government which legislates or which makes the law for our country, right? And executive is that organ of our government which executes the law, which executes or implements the law which are made by the legislatures. And the third organ of our government is judiciary, which makes the interpretations of the legislations made by the legislatures, right? In America, this principle of separation of power is strictly followed. That is, they are very strict about this thing. Nobody can interfere in each other's functioning and doing of the work. But in India, you will find that there is some overlapping between all the three organs, right? And so, as I have already told, that this I'll be covering why and how there is overlapping. So let's read. Okay, so yeah, legislature, it makes the law, executive implements the law, judiciary interprets the law. That is, they also take care whether the law is as per constitution, as per the constitution. Therefore, it does. Therefore, it is also in a way, judiciary is also in a way doing checks and balances of the law, right? So apart from interpreting the law, the checks and balances is also kept by the judiciary in our country, right? Lord Acton, he says power corrupts and absolute power corrupts absolutely. So you must remember this name, Lord Acton, right? It is. And he says power corrupts and absolute power corrupts absolutely. So what he's trying to say is that whenever you give power to any person, no, then that person tends to have a tendency that is to misuse that power, right? So this is what he's trained. So whenever we give full and absolute power to anyone, no, so he is definitely going to misuse that power. For that purpose only, we need to have the system of checks and balances. And generally, and it is done by judiciary in our country. Right. So as I was telling you before, that in India, there is some overlapping between executive, legislative, and judiciary. How? See, ordinance making power. Whenever the parliament is not in session, generally what happens? The ordinance is made by the president, right? And similarly, in the case of death sentence, whenever a death sentence is given, it has to be confirmed by the High Court, right? But in that case also, what you see is that pardoning power has been given to the president, right? And whenever there is a legislature makes any legislation, it has to take the assent of the president. So in ordinance, you see, so let's take this assent part, assent example, wherein the legislature makes the law and assent is given by the president. So president comes under the executive, right? So don't you see that there is an overlapping? Law is made by legislature, but he is seeking the assent from executive body. So this is where you see the overlapping. Similarly, in the case of death sentence also, death sentence given by the courts, but pardoning power has been given to the president. President again is the executive body. So he can, you see that he is able to intervene in the functioning of legislature, right? So this is where we see that, in India, all the three organs are not independent. They all are interfering in the functioning of each other. There's a case, Ram Javaya versus the state of Punjab, which was held, which is of year 1955, Supreme Court judgment. In that case, it was held that Constitution has not recognized this doctrine of separation of power in absolute rigidity. Right. So in this case, it was clearly held by the Supreme Court that this doctrine is not rigid, and there can be intervention of other organs in other organs functioning. Right. Essentially, three organs perform their respective functions. However, each organ is dependent on the other organs in some or the other aspect, which checks and balances the working of the other organ. So what is this saying? In India, when there is interference by the other organs in the functioning of the other organs, this is also, by this, actually, we are in a way keeping a track or a check upon the functioning of the other organ, right? So that the other organ is not doing anything which is not constitutional, or it is not abusing the powers which are given to them, right? Now let's come to the purpose and definition of the administrative law. So let's know the purpose of the administrative law. When the powers and the functions of the executive increase, there is always a danger that authority may exceed its power or may act arbitrarily. The purpose of administrative law is to see that the authorities act within its power according to the fair procedure and do not abuse their power. Administrative law is mainly concerned with the powers of the executive branch, right? So the basic purpose is that no organ of the body acts arbitrarily or exceeds the power which are given to them. They do not abuse the power which is given to them. right? It is basically to check that there is a fair procedure which is followed. So basically, they are talking about checks and balances which has to be done. There were many jurists who tried to give the definition of administrative law, but so far the definition by Wade has been considered to be the better one with respect to other definitions which were given. And he says administrative law is the law relating to the control of government power. Now, when we talk about administrative laws, then we definitely have to talk about the principle of natural justice, which is also called the principle of substantive justice. It is basically based on three principles, that is, nemo, debet, est, judex in propria causa, odi altrum partem, and third one is speaking order. So now we will be covering each one of them one by one. Okay. Just a second. Just a second. Give me a minute. Yeah. So let's let's read the first principle, that is nemo debet est judex in propria causa. Okay. It says principle of natural justice is a humanizing principle intended to invest law with fairness, to secure justice, and to prevent miscarriage of justice. So what actually it is saying, in the principle of justice, what you have to see? You have to see that there is no arbitrariness, no misuse of power, no miscarriage of justice. Basic purpose that you have to see is that justice is done, right? You can't misuse the power. So this is what basically they're saying. It can be enforced against courts, judicial bodies, and quasi-judicial bodies. Give me a second. I'm not able to find the cursor. Okay. So yeah, earlier this principle was not applicable to the administrative body. But then there was a very important case, which is known as Magna Carta of natural justice, which is the case is Ridge versus Baldwin. In that case, it was held that natural justice is applicable to the whole range of administrative powers also. So yeah, you can remember this case, Ridge versus Baldwin, which is also known as the Magna Carta of natural justice. In that case, it was held that natural justice is applicable to the whole range of administrative power. Similarly, the same situation is also in India. In the case of Eki Kripak case, it held the same, that natural justice is applicable to the whole range of administrative powers. That is to say, natural justice will also apply to the administrative law cases. Under this first principle, you will find basically this is under the first principle, there is what they're talking about is rule against bias. They are basically talking about three things. That is, they're saying it's a rule against bias. That is to say, they want to say that no man shall be a judge in his own cause. So this maxim, which is nemo debet es judax in propria causa, it means rule against bias, right? And under this, they are talking about three biases that we'll be discussing after this thing. Under this maxim, what they're basically trying to say is that justice should not only be done, but it must seem to be done. Judges like Caesar's wife should be above suspicion. So basically, what the principle behind this maxim is that judge should be neutral, impartial, act judicially, and decide matter objectively. That is why they are saying no one can be a judge in his own case, which means if you'll be judge in your case, obviously there will be some bias attached. No, so that is why. So this is what this principle is talking. And when they're talking about bias, they're basically talking about three types of bias. That is pecuniary bias, personal bias, official or subject matter bias. So when they talk about pecuniary bias, that is to say some money is involved in it. It does not matter how much money is involved, even if very less amount is involved, and it is possible that the judge has very slight possible interest in it, then he can't be a judge in that case, right? The amount of money does not matter. Even the slight possible interest with respect to that money will make him ineligible to be a judge in that case, right? Second bias that they're talking about is if judge is related to you anyway. Suppose there's a case and what happens that the judge turns out to be your relative, maybe your brother, sister, or any known person, friend, or etc. Then in that situation, the judge should recuse. That is, he should ask not to be the judge in this case, right? For this, we have a case law. It's a very important case law with respect to this topic, that is personal bias case. Same case, A.K. Kripayak versus Union of India. So what happened in this case, there was a selection of candidate for the post of Indian Foreign Services. And actually what happened in this case was that candidate was also in the selection board, was also part of the selection board, which was selecting the candidate. But when his turn came for interview, when his turn came, of course, he was not sitting there in the panel to select him. So, and in fact, even when the board was making discussions as to the selection of other candidates, he was also not part of those discussions. And he was selected for this post. But later, he was disqualified following this maxim, because you can't be a judge in your own case, because in a way, he was a part of that board now. When that does not matter, he was not sitting at that time, but the judges were known to him. He was very much familiar with those persons who were deciding the candidates to be selected for that position. So on that ground, on the basis of this rule against bias, through personal bias, he was disqualified. Now, the third bias is official or subject matter bias. In this bias, actually what we have to see is that if the judge has any sort of interest with respect to the subject matter, then he can recuse. He should not be the judge in that case. Fine. Now, let's move to the second principle, that is audi alteram partem, which means no one should be condemned unheard before taking any decision against anyone. That is, he must be given a hearing. That is to say, what they're trying to say under this principle is, whenever you are deciding against any person, give him the chance, give him the opportunity to show cause notice that why the action should not be taken against him, right? He should be given the right of hearing. And in fact, reasonable time should be given to reply. It is not that you can ask, that you'll ask him to reply in a short span of time. No, give him a reasonable time to reply so that he can think of a prudent reply that which he should give, so that things may not go against his favor, against him, right? So give him the proper chance of putting forward his point of view, right? So basically, two essential elements are involved in this. One is notice, and the second one is hearing. By notice, it is to be noted that notice is to be given. If order passed without notice, then the order will be void ab initio, right? See, what if you're taking decision against anyone, give him notice. At least he should be intimated that something is going against him. He should be informed, right? If you do anything without intimating him, without giving notice to him, that order or decision will be considered void ab initio. Second is hearing. Like in the Maneka Gandhi case, when her passport was impounded, she was not given any hearing, which was considered against natural justice. Okay, now let's go to the third principle. That is a speaking order. That is reasoned order should be given. Whenever any decision is taken, it is not that you are just giving the order without backing it with any reasoning, or without backing it without any reasons. So if you're deciding any case, if you are deciding in favor or against, always support it with your reasons. Why, how this decision has been taken, what were the bases, right? So there are two important case laws which talk about this. The first one is Siemens Engineering Company versus Union of India 1976 Supreme Court case. In this case, it was held reason should be given in support of an order. That is, always give reason whenever you're giving an order. And the second case is S.M. Mukherjee versus Union of India. It's a 1990 Supreme Court case. And in this case, it was held requirement of recording reasons can be regarded as one of the principles of natural justice, which govern exercise of power by administrative authorities. Okay, now let's know. Okay. So yeah, that's it for today's class. We'll be covering the remaining portions in the next class. So this is it for today's class. We'll be coming back. So thank you.